Discuss corrections and institutions. It is Wednesday, February 19th, and we are shifting gears a little bit in that we are now with building community grants. So if you go to your tab for building community grants, and I know that we've had testimony on our historic preservation and our bond grants, cultural facilities and our rec facilities, and there's one more grant that we haven't heard testimony on yet, and that's with our ag fairs. We also do, that's on page 15 of our book, and it is on line 58 of our spreadsheet. And what the governor has proposed is 300,000 this year for barn grant, for ag grants, as well as 300,000 for 27. And if you compare that to some of the other grants that we fund in the building community grants section, it's a little bit higher than some of the other grants because there may be some more pressures on the ag fairs than has been in the past. So I'm going to turn it over to Bob Allen. Welcome, Bob. You can sit. You don't need to stand. You can sit in the hot seat or stand, whichever is more comfortable for you.
I was going to stand, Chairman, because we've got 6 minutes here, and I know you're tight on time, and some of us are as well. So I've got the Vermont State Fair, Addison County, Orleans County, Tunbridge, Caledonia County, and Champlain Valley all represented here today. And I have warned them, and I'll warn them again, keep it short, 3 to 4 minutes. These people are very busy. So with that said, let's start with Christie. Want to go first?
Sure. I think one thing
State Fair.
that would be important is to talk about how the state money through the grants program, what those dollars go for at your respective fairs.
Done for capital grants and
Yes.
where you
That
are.
would be very important.
You can have the chair.
I'll stand.
Okay.
I need to stand. All right, I'm Christy Davis. I'm from the Vermont State Fair down in Rutland. And this year, our grants went to improving our bathrooms in our 4-H building. They are ADA accessible. We're also putting in showers. We also have improved our water system on the agricultural side of the fair, which we will continue to improve on. And this year, we are going to continue with our bathrooms, finish them up, get the showers in. We're going to do more water systems. We're adding another ADA bathroom down in our agricultural bathrooms. So more accessibility for everyone. And we just thank you so much for helping us fund all these projects and just to improve our buildings. And we're going to also make the second floor of our historic 4-H building ADA accessible. So we will have it. So any ability to get up to the second floor and see the exhibits we put up there.
So one of the requirements here is that each fair put % match minimum. And what was the amount of your state grant that you received for that work? Do you remember?
I don't remember off the top of my head.
It's the 300,000 or the 250,000 are divvied up. The process is there is within the Agency of Agriculture, there's a ag board, agricultural fair board that looks at the applications that come in from all of our state fairs. And then they work with the state fairs on the project, but also making sure that there is a match from the respective fairs and what the dollars go for. So that 300,000 gets divvied up as equally as possible between all the ag fairs in the state. And the list of the ag fairs on the back here. Okay, so there is a process for the application. There's a process in terms of determining about the project and what it goes for.
I can't remember the exact amount because we were working on completing our grant projects from the year before. And we finished ours and we put in more money than what the grant was to finish our projects. So we have already exhausted our grant and gone beyond that. I want to say it's 25,000, but don't hold me to that because I'm not 100% sure on that.
I heard your question, and so I just wanted to speak to it. I'm on the grant committee selection group as well. And when we do that, we take the number of fairs we got and divide it in the amount of money that you folks have given us, and thank you very much. And we start at that level. That is what the maximum grant can be for any one fair. Some fairs do not request the full amount. So whatever is left over, we go back and divide that money amongst the fairs that have a big budget for something like that, so that they get a little additional help from that. And 15% is the minimum that they can contribute. That's either cash or in kind. And I gotta tell you, last president, very low. It's in, when you talk about in kind and cash, way over 15%. So just to answer the question.
Right, that helps, because we have new members to the committee, so this is new information for folks.
But what would be an example of in-kind?
Well, let's say you have a contractor in the area that donates his time to do some construction work, prepare the ground,
Got it.
maybe lift trusses, whatever, that type of thing.
I assume, but I don't like to assume.
Yeah.
And like our fair board puts in countless hours on every project, whether we know what we're doing or we don't. Not this past year, the year before, we replaced the roof on one of our buildings. And we had the president, myself, and one of the board of directors who did it. So we were up there with the metal roofing and we did most of it ourselves.
Yeah.
But thank you so much.
You're welcome. So who's next here?
Hi, Tim Shea, Champlain Valley Exposition. Well, keeping the standing here. I'll be brief. I know you folks are busy. I just want to say thank you. The capital dollars, I will add that the capital projects, they also have to have a lifespan of 20 years or more. As an example, we last year received a $33,000 grant. We replaced the roof on we call it the Blue Ribbon Pavilion, $80,000 roof. So we covered the balance of the project, and that goes on and on. We've done electrical upgrades over the years as the standards for electrical gets greater and greater. And again, a lot of this is aging infrastructure. We've been around for 100 years, so there's a lot of roofs, things along those lines that we continue to repair and replace, and the state dollars allow us to do that. So I just want to say thank you for the continued support of affairs.
Welcome.
Thank you.
Who's next?
Addison County.
No,
I don't know.
Caledonia? Going once, going twice?
Yes. Jeff Goodwin from Caledonia County Fair. Thank you for having us. Over the last 3 years, we had 5 old cow barns. Over the last 3 years, we have completely rebuilt those cow barns. And the beauty of that is we were able to steal the New England Holstein Cow Show from New Hampshire Fairgrounds. So that's a 4-day event. So this year, our grant, last year, we weren't able to spend our grant money. Our project came in extremely over what we were thinking it was going to be, and it was just unable to do it. So we had to throttle back. So this year, we will be doing that project with last year's and this year's. And we have a show ring, and we have bleachers in that show ring. We have people right down with the animals. Very unsafe. So we are putting a wing on the side of each of the building, and we are going to be moving the bleachers outside of the show ring and to make it much more safer for everybody's spectators and everything. As you know, we can have some very big animals. It is also because with all these new barns and stuff, we are getting a lot more participation from our agricultural community. Barns are full. The showroom is full. So we are going to be able to have two shows going on with smaller animals at the same time. Like one will be judging, they'll have another show going on. So that'll help alleviate the burden of extreme amount of youth in that children.
Did you name the new barns after Dick Lawrence?
Actually, the show ring this year is the Lawrence Arena.
It's like,
Yes. So, yeah,
because of him that we have the ag fair grants.
absolutely, absolutely. Dick was a very, we've had a lot of support from this building, so. And Dick is very missed. We miss him every day.
He's missed in this building too.
So thank you for your time.
Thank you, Jeff. Thanks.
Next. I feel like it's a waiting room.
Good morning. I'm Jason Seacart from Orleans County Fair in Barton, Vermont. I want to take a moment to express our heartfelt gratitude for, we've got 3 capital grants that have been awarded to us in the past years for a new horse barn structure. And so that's a sizable amount of money. And I'm very pleased to say how it energized our community. The Kingdom Hoofbeat. Saying it too fast. Yeah, Hoofbeats. Kingdom Hoofbeats is our 4-H program. They developed the idea to replace 3 barns on our property. So this barn that we're raising money for is for that. And this group with their children and the leaders all have raised where they have matched dollar for dollar for the 3 years that you've invested in us. And we are pleased to say that we've got the next year grant also awarded to us for that project. All the materials are purchased and we're going to start groundbreaking this year. So that's our Gymkhana event will take off from that. We have started, last year we did 1 show for the high school rodeo. And this year we've got 3 shows scheduled for that field, which is, this barn will be adjacent to that. So we see a lot of economic stimulus happening from this. This is really, really good. It's one of the biggest projects I've been involved with at the fair, and I've been on the board since 2009. So many projects have happened over the years, but this is the largest undertaking that I've seen happen since about.
I think one thing that's really important, a lot of these projects may not have been happening at all or as quickly if it wasn't for the infusion of some state dollars.
That seed money it helps the volunteers get started, right? Otherwise, it's really hard to sell yourself to people to get money handed to you. But if they know you've already got a momentum behind you and they can see it happening, it really, really helps. Yes, thank you.
Great, thank you.
Good morning. My name's Ken Button from the Addison County Fair and Field Days. Capital grants, we try to do a project each year. Let's say roughly the grant covers 1/3 of the cost. And our grants may be 27 to 34,000 per year. It's sort of rambling, but one year we did a long antique tractor barn that was cost 90, and I think we spent a grant might have been 30. So that's the ratio. We've always tried to think if we can build a building, we eliminate a tent, because tents have become hard to get and very, very expensive. So that's been a focus. Other projects, we've done electric upgrades, Tampa line upgrades. Last year, we did a lot of crushed stone roads, culverts after the disaster of 2023. This year, we're planning to do an antique house. Again, it's thinking of the eliminated tent. And it's a project that we've been putting off for the last 5 years. And the estimated cost is $115,000. And I think our grant was around 37 this year. So I'm back to that 3rd ratio.
Terrific. Thank you.
Hi, I'm Peggy Sherlock from Tunbridge Fair. We want to thank you for your support of our fairs. It's a big help. We'd spent our money on lots of different things, electrical upgrades. It seems like we're always upgrading electrical and we're never good enough. And so our next grant is actually going towards electrical. The last one we used for the bathroom We took down an old bathroom and put up a brand new one with ADA showers, and it's much nicer. And if you know people like nice bathrooms. We also built a new building, took down an old decrepit bingo hall and put up a heritage hall where we can display a lot of our heritage. This is our 153rd year this summer, so hopefully you will all come. We're 10 days after Labor Day, a 4-day fair. Our grants, we always put in for the max, and thankfully we've gotten it. It tends to be around 30,000. If there's 10 fairs and there's 300,000. We don't get the whole bunch at once. We get most of it, and then some is held back until the project is done and all the paperwork is in. So there's always I think it's 10% that comes at the end of the project. But for example, the bathroom, $162,000. I mean, stuff is expensive. So, if we can have some money to start and give us the oomph to go, and then we go. So we thank you very much for the support. Any questions?
Sure. Questions?
Hopefully you'll all get to the fairs this summer.
Future.
No, we do get
Mhm.
passes.
We do.
We'll be getting passes in the mail. So hey, you did perfect. You got it down pat.
I can compliment how efficient you guys are.
I just have one thing to say. Jeff was proud of stealing the Holstein agriculture
We did
from a
that.
fair in New Hampshire. And I just happened to be the director of up in the state fair in New Hampshire who had the Holstein show. He stole, which is fine. We're all friends.
That's great.
Thank you.
That's great.
Does anybody besides Champlain Valley have the Mackenzie Racing Pigs?
We had Rosaires racing pigs, but they're not coming this year. We're having a different group.
Been strangely attracted to the Mackenzie Racing Pigs.
Here we go.
That's what I thought.
Cabaret, here we go. Committee skit, dress Joe up as a pig. I do have a question, and I hate to ask this question. But I'm gonna. I noticed that Franklin County is not having field days this year. Yeah, well, we've been living it in this committee part of it. At some point, maybe we do need an update on what is happening up there in terms of where we're trying to find the land.
Joan, I can tell you all about
We'll get there.
Yeah.
But with that fair not being held this year, and we're really uncertain how it's gonna progress going forward. Does that impact any of the shows that you were able to bring into your fairs? Because I know that there's a connection there. If one fair can bring in a show or an activity, then it can go to another fair in the state. And if one fair isn't operating, what impact does that have?
Can you speak to that?
Dreamland Amusements does a show at Addison. And at this time a year ago, Dreamland had told Addison, if we don't have Franklin, we can't afford to drive from our location to do Addison. So you guys are out of luck. So we were not feeling so good. But then during the fair last summer, they said to us, since Franklin is not going to happen next year, if you guys would move your dates back a week, we could work you in, because they have some other gig somewhere else in the vicinity.
Nearby.
So we came through it, but yes, that was, answer your question.
That is a big one. The travel for these carnivals, when they bring in 18-wheelers, they don't want to go from point A to point B and back to point C. They make a route and they stick to it, and they're willing to give up a fare in order to stick to that route, which they had threatened Addison with. Addison moved their dates back, didn't conflict with any other fair, and it worked out great. Hopefully it'll work out great for Addison. It worked out great for Greenland.
But it's a lot of networking, like all the vendors, everybody's schedule, it's a lot of change. But we have to do it to follow the carnivals.
Yeah, yeah. So is there hope that the Franklin County Field Days will continue, or what are you folks working on
I think
putting on the ground?
They are working to find a piece of land that they can either purchase or lease. And I don't know the latest status on that, Alice, at this point in time. We've got a agricultural fair meeting coming up in March or April. We've had our one in January, so we'll get more data at that point in time. But right now, I can't tell you where that stands.
So our last meeting with them is
Is this your delegation?
this is our delegation. We meet with them and Senator Norris is on the board now.
Right.
They are looking at a piece of land. There has been other lands that fell through. But we finally got them to the point of hiring an attorney rather than just, it was a chore. But hiring an attorney to actually go through potential purchases and sale agreements and not to get into details of where it is or all the other details, but it just wasn't gonna happen this year. And, with enough progress, they probably would have been able to open in the same location this year, but that this wasn't gonna happen because the progress wasn't happening. And so, but hopefully for next year, but I would be hesitant to say that that's going to be the case. But there is a piece of land that's being looked at. There's lawyers being hired finally to look at the stuff and yeah.
I would only say, having been in the fair business for a long time, once a fair closes for any period of time, it is very difficult to open back up again. Windsor County Ag Fair is a perfect example.
What I was thinking when you said that.
Well,
Anyhow,
not to get too far down it to be, it's from, we've been trying to push this for years and just, there's a lot of conflict of, we don't want to move, and well, it doesn't matter. The dictate you have to move. So that fight has kept people from moving to find new property. So we finally got it, like, there is no stay. You have to find a place to go. And it stinks, but hopefully it works out.
So there has been previous fiscal year appropriations and of our ag fair money that has been committed to the Franklin County Field Days. There's probably about 90,000, I'd say. So we're gonna have to resolve that at some point. I know we gave them last year more latitude, and we gave them, extended the time frame in terms of when they can keep that money, but we may need to look at that because it's pulling money away from the rest of you.
I think that the Agency of Ag has held back some of that money, Alice, and is not actually given it to them.
Yeah.
Till this has been settled.
Okay,
You know more about it.
Yeah, no, that's the case.
so we'll need, I want to do some follow-up with that because I want to see what money is out there that
It's an interesting.
I just don't want to leave money on the table. I don't want to hurt Franklin County Field Days. I know we've been working for 2 or 3 years with them, trying to figure out how they can move or where they can move and to keep it viable. But these little grants are holding back 60, 90,000 impacts the rest of you. And I think at some point we're going to have to make a decision. So we'll have a conversation with the Agency of Agriculture.
Be a tough decision. I'll leave that to you.
It's going to be tough.
I'd be glad to help you in any way I can. You know how to get a hold of me.
Right.
Okay.
Great. Thank you. Anything else for folks? I want to thank you all for coming in.
Thank you.
Thank you, Maple Syrup. I also look forward to this, and I want to also thank you for what you provide for the agricultural community in the state and for Vermonters.
Yeah.
We really appreciate that. Thank you.
Take a look at the economic statement I passed out. That'll give you a good idea.
Great. Thank you.
Come to the fairs.
Always do.
You did.
Yeah, I've been in Champlain Valley Fair in 30 years.
I've been in it for a couple of years.
And I've gone to the other fairs too. I like them.
Well, my favorite fair was at Walmart. I guess they're not the market.
How to deal.
How about the pit?
Ferdinand,
Yeah.
Ferdinand.
I
Didn't
don't,
even know that.
Ferdinand. Yeah.
Mary, why was it there's a root fair? Are they not part of this organization or are they just separate?
I think they do their own stuff.
Yes, okay, that's what I
That
was
way.
saying.
over there. Invited them down there to the meeting.
Oh, field days, yeah, there's.
Tried with all you folks last year at the beginning of the session.
Gina. Gina, you're in trouble.
Joe can tell you.
Oh, boy.
Ooh.
Okay, we're gonna shift gears, folks. We're gonna go to H32. We're shifting gears now. We're talking corrections. Welcome to the world of being a money committee and a policy committee. Welcome to the world. At least it's not boring and it keeps you focused. Because if you get bored with one thing, you can focus on something else.
Never get bored of that.
I know there's
Never.
always something you've.
We're developing.
So H32 is the one that it's Representative McGuire's bill for Troy. Oh, good, we have Tony on Zoom. And also Troy Hendricks, Representative Hendricks.
Eric McGuire.
And McGuire, but
It's listed for
it's
You
just
just
what?
listed.
Listed.
alphabetically. Getting hung on my. Happy.
So we had Katie McLean, who is our legislative counsel, walk us through the bill first, and then we had some testimony last week from DOC that could have been very confusing because we need to look at the language in the bill. Not just kind of high level policy, but we need to really look at the language, understand what the language is saying, and make policy decisions as a legislative committee, and then the language will reflect our policy decisions. So our legislative council has been willing to help us kind of focus how we move forward. There's been interest in this committee to work on this bill. And we need to spend time understanding the current structure, MOUD, both in our facilities as well as out in the community. But we also need to understand limitations that may be placed in terms of a hub and how that plays out in corrections. And then when a person's incarcerated, what their relationship is with their primary care provider, if they have one, and how that works with our contract we have. And then as a person then works towards reentry, how those connections work or do not work. So Katie came to me and was willing to really help us focus in terms of what are we really looking for and what are we trying to achieve. And she put together this checklist, policy decision checklist. Some of us had the paper copies, the others could be online for that. So I'm going to ask Katie to come up and we're going to work through this line by line and make some decisions.
Is this through the bill now or through the checklist?
Checklist, never mind the bill,
Thank you.
never mind the bill.
Like
Because what will happen whenever we make a policy decision, Katie will then draft language that reflects our policy decision. So we will have what is new to new members. Legislative term is a strikeout. We will strike all the language that's in the bill as proposed and replace it with language that reflects where we're headed as a committee in terms of policy. Does that make sense to folks?
Sure.
Okay. So Katie, I'm gonna turn it over to you. And Tony, we have Tony Fallon from the Department of Health, who works directly with our hub and spoke model and directly out in the community with our providers who provide the MOUD system in the community. So at any time, Tony, if you want to weigh in, just feel free.
Thank you,
Okay?
Madam Chair.
And I hope you're feeling better.
I am, and my apologies to the committee for not making it last week. I had come down with the flu, so my apologies to you all.
Like everybody else is having the flu.
Tony, we'll forgive you this time.
Feeling better.
Thank you, sir.
Katie, it's all yours, so help us.
Okay, thank you. Katie McGlynn, Office of Legislative Counsel. It's nice to see everyone. What I have prepared for you today, as the chair has told you, is a policy checklist. Sometimes I find when a committee is sort of circling around an issue, it's nice not to look at the words on the page and sort of get back to the question, what is the problem we're trying to solve, and start there. Before we walk through the checklist, I wanted to spend 3 minutes talking about separation of powers, because I know there was a concern raised and I want to address that. I thought I'd walk you through the constitutional underpinnings a little bit of separation of powers. So our Vermont Constitution tells us that the legislative, executive, and judiciary department shall be separate and distinct, so that neither exercise the powers belonging to the other. So we have sort of 3 distinct jobs that the branches do. The Vermont Constitution provides that the supreme legislative power shall be exercised by the Senate and the House of Representatives. The Senate and House of Representatives may prepare bills and enact them into laws, and shall have all other powers necessary for the legislature of a free and sovereign state. So that comes from our Vermont Constitution. The Vermont Supreme Court has weighed in on this and has stated that the General Assembly's supreme legislative power is practically absolute, except for constitutional limitations. Those constitutional limitations would be something like the governor's veto. That's a constitutional check on the legislature's authority. However, as the court looks at a separation of powers argument, it must determine the powers of each of the branches to ensure no one exercises powers belonging to another. But this process also involves recognition by the courts that there must be a certain amount of overlapping or blending of the powers exercised by different departments. So the court looks at the fact that there could be a little bit of overlap between the branches. Therefore, separation of powers doctrine does not contemplate an absolute division between the duties of the 3 branches of government. The focus of a separation of powers inquiry is not on whether one branch of government is exercising certain powers that may in some way pertain to another branch of government. Instead, the focus is whether the power exercised by one branch of government so completely encroaches upon another branch's power as to usurp that branch, from that branch, the whole of the branch's constitutional function. So that is what the Vermont Supreme Court has told us. We're looking at whether there's an overstepping when one branch of government so oversteps as to totally usurp the constitutional authority given to another branch of government. The Vermont Constitution charges the executive branch to take care that the laws be faithfully executed. The governor is to expedite the execution of such measures as may be resolved by the General Assembly. So without having a more articulated argument as to why the underlying bill violates separation of powers, I can't dig in too much further on that, but I can tell you that what I understood the argument to be is that the legislature had to have very general legislation and couldn't be too prescriptive in the details of its legislation. I wasn't able to find any case law that supported the premises that the legislature had to have generalized or high level policy making so as to avoid virtually usurping the executive power. There are times when the General Assembly chooses to delegate its policy making authority, and that is what rulemaking looks at. There are lots of policy reasons for doing that, but not necessarily a constitutional reason for doing that. A policy reason for doing that would be that there's more expertise within a particular department. So the General Assembly makes the choice to delegate policy-making authority to the individuals with the subject matter expertise. So with that, I'm going to shift gears and look at our policy chart.
So just for the community to give focus, if you remember testimony last week that we received from DOC was saying that this bill, in particular, some sections of the bill, was the legislature really telling DOC what to do, and it was a violation of the separation of powers. And it was telling the executive branch more what to do. So that's why our legal counsel has spent time explaining that there is a balance there. And that the bill as drafted is not violating those separation of power issues.
Without understanding in any more detail what the argument is, at this point in time, it appears that there's nothing in the bill that so totally usurps the power of the executive so as to cause a violation. With more specificity, I could do a more detailed analysis. Okay.
So we have a question, can you, Brian?
Well, and then this maybe for DOC, I mean, does that sort of resolve the question, or does the, objection remain regardless? Where are we at?
Yeah,
I think we need to figure out what direction we're gonna take in the bill.
And then get back to that question?
Yeah.
Never mind.
May I respond?
Sure, but I just want to put out for the committee, we may be changing the language in this
Yes.
substantially. Okay, we just don't know yet.
No, thank you, Ledge Council, for walking through, and I'm looking forward to the checklist. I think that's a really smart idea as the committee starts to contemplate what problem we're trying to solve. We did just come from testimony downstairs in Senate Judiciary around S44, which does contemplate like some, again, separation of powers argument, different.
What does S44 relate to?
That is the one about the the state entering into contracts with the federal government.
Yeah, okay.
So I think that's probably a clear one. I mean, I think, it specifically are some of our concerns around the MOU provisions, because the state cannot enter into MOUs with non-governmental agencies. That's our state policy. We could probably put in a no-cost contract or figure out some other way around some of that language, but I think we were just a little bit concerned around some of the provisions in the bill as drafted as it related to the carrying out of the policy.
Well, let's go back to our checklist because I think the bill's going to change quite a bit, depending on where we go with our policy decisions.
So I'm pulling up the policy checklist now. I thought maybe I would walk you through some of the points in it and then start back at the top again, if that would be useful. So we sort of have the range of types of decisions we're making. So I always start with the question, what is the problem you're trying to solve? And I've put suggestions, but this is sort of a limited list. There might be other problems you're trying to solve. Is it that the MOUD services and correction facilities are inadequate? Is it that there's lack of parity with the community? Is the problem that you want to improve diagnosis of individuals with opioid use disorder in a correctional setting? Is it that there is a lack of coordinated care through reentry? Is the problem trying to reduce diversion in a correctional setting? So what specifically are we looking to solve? And then under Roman numeral 2, who should be responsible for the delivery of MOUD in a correctional facility? Should it be in-house DOC staff, WellPath, or another entity under contract with DOC, the hubs and spokes, via an MOU or otherwise? Counseling services provided by the same provider as who's providing the medication itself or by a different provider. So there could be others, but that is a list to get you started thinking about who should provide, who is responsible for the delivery of these services. Roman numeral 3, when or under what circumstances is a person screened for opioid use disorder? In statute, we already have language around that. Maybe you don't touch it, or maybe you want to look at it again. 4, Roman numeral 4, what MOUD medications are provided? Do you want the language to be prescriptive that would identify the specific medications and under what circumstances? That's similar to what you have in statute now, that somebody has started on buprenorphine and then they could potentially be moved to methadone if the circumstances are as outlined in statute are met. You could have broader language that would give DOC more flexibility to make changes as new medications become available. Under Roman numeral 5, who receives an MOUD? We've had a conversation about there's some language in statute that talks about an offender. There's some language that talks about an inmate. Maybe it's fine to use both terms, but we should at least go through instance by instance and figure out who we're talking about in what instance. Roman numeral 6, how should reentry be addressed? What preparations are required prior to pre-entry? Should individuals have a literally individualized plan for each person leaving a correctional setting? What kind of connections or appointments with a community provider shall be set up? What medications and prescriptions shall be provided? How many days supply? Should there also be a prescription issued for continued supply? What type of case management services shall be provided after reentry and for how long? Roman numeral 7, what trainings or other considerations for staff shall be addressed? Roman numeral 8, what data collection is necessary? Data points and reporting frequency. What information do you want to collect and how often do you want to collect it? And then also Roman numeral 9, what funding considerations should we think about? How is this going to be funded? As an extra question, this is all focused on MOUD. As we saw, MOUD current statute impacts a statute that's also about medical care generally. Are you going to be looking at that at all? Or maybe not? That might be outside of the scope of your focus for this bill. So maybe I'll start back at the top and start with what is the problem we're trying to solve?
That's the question for the committee, right? Not for Katie. Question for the. So what problem are we trying to solve? Inadequate services, lack of parity with the community? Do we need to work on improving the diagnosis? Do we have a lack of coordinated care for the reentry if somebody's on MOUD? And how do we want to address the diversion issue? Troy.
I helped sort of draft this bill request. So I don't want to direct the conversation. In general, I am worried. I'm always going to be worried about parity. Are the folks who aren't incarcerated getting the same level of treatment that they would receive if not incarcerated? And mostly, and this, I've been thinking about how I want to get this into the bullets. So it might be a new bullet. I'm worried about the fact that we're sort of reliant on who the medical provider is at any given time. There's nothing in statute. Well, there is, but there's not a lot of detail in statute that would require a new provider, whether that's private or not. I have my thoughts on that. To deliver MOUD, and your final question is noteworthy as well, but in this case, MOUD, right? So if the WellPath contract ends and we suddenly have a new provider, there's no framework really in statute that sets up the expectation for MOUD. So that's a concern of mine. Certainly want to fine tune that second to last bullet as well, the coordinated care through reentry. And we have since learned, this wasn't on my radar until recently, about how much administrative burden there is due to potential diversion. I think about especially when we're waking incarcerated individuals up at 3 a.m. just because we have to administer the line. That to me feels like a response to worries about diversion. So that certainly rings true for me as well. I'll stop there for now.
Good folks. Sean and then Brian.
I just have your last thought there, Troy. Can you expound on that a little bit? I didn't quite follow you on that.
So we've heard testimony that we have to start delivery early in the morning to manage the line that develops. And the line develops because we have to watch to make sure it has been taken, received, not diverted before they depart, right? So that's perhaps, DOC could tell us more specifically, but maybe that's a 30-minute process that could be scaled down to a 3-minute process. If the administrative hassles are primarily safeguarding against diversion, then yes, we should reduce diversion because I think it's going to have a positive impact on the delivery of the administration.
Okay, gotcha. Thanks.
Yeah.
Right?
Sort of the general principle, and I don't think this goes necessarily back to the separation of powers, but I remember when I was on the education committee and we were talking about pedagogical matters like literacy, for instance, there was a real leeriness to be prescriptive or proscriptive. There were some folks who wanted one method in particular to be tossed and it needed to be in statute. And I hope we're going to rely on what the experts say is the right amount of medication, the right amount of time, the right amount of everything. I assume that's going to guide everything that we're doing on this.
We're gonna work through as a committee.
Yeah.
Yeah. So we're in the first Roman numeral. What's the problem we're trying to solve?
I asked Troy to clarify. I don't understand the lack of parity. My perception is those who are on the street rather than being incarcerated do not have housing, medication, safety, and meds provided to them. So I don't understand the concern for the lack of parity, because if you're incarcerated, you're getting all of those benefits, even though it's against your will to be imprisoned. What am I missing on the parity part?
Treatment is certainly available for non-incarcerated Vermonters.
For MOUD.
Yeah.
It's the delivery of services for MOUD.
Yeah. Yeah. So
that's what we're focused.
And we've heard testimony that our hub and spoke model is outstanding. I'm not convinced, or I'm worried at least, that the hub and spoke model, I just want to get in statute that we are, as a state, absolutely certain that our hub and spoke delivery model is also provided for our incarcerated Vermonters. That's what I'm working on, right? So we do have a robust MOUD program, in the state. I want to make sure that by statute, our delivery within our correctional facilities is equally as robust.
So maybe I can throw the ball to Tony, because we were very clear. And Tony, you were in the committee when we were working on this a number of years ago, when we first established the MOUD program within our facilities. We were very, very clear that for MOUD, we provided the same level of service as what is out within our hub and spoke community. We did not want to provide more than what is provided out in the community, and we did not want to provide less. So I don't know if, Tony, you can weigh in on that, how you're seeing it from your world of working out in the community with a hub and spoke, and also working with what is provided in DOC. So I'm turning it over to you.
Thank you, Madam Chair. For the record, Tony Follen, Department of Health, Division of Substance Use. To your point, that was the drive, the North Star principle as we developed this, that no more, no less, that we would provide that level of parity. And I think where it comes down to is that I do believe that we are providing the same level of service. In fact, and to your point though, Representative Hedrick, how do we put this, how do we repackage it so that we know going forward that it consistently stays this way? Right. We did build in the fact that therapy had to be available. Just the continuity of the community, we make it available, but it's never required. Because again, to require something means that if an individual doesn't engage, that we would remove life-saving medication from them. We always want availability, but we've never made that a requirement. When we built the system in corrections, we actually built in the robustness of nursing supports and care management to really support folks. So it had clinicians involved who would provide less therapies and more of that coordination of care, more of the, to the point of diversion, looking at what might be the drivers of diversion in the event that somebody has been perceived or determined to have diverted medications. Was that an issue of the individual did not necessarily need that level of medication? Was that an individual who was actually subject to coercion, in which case we needed to do something different? But to really do those kind of very practical clinical interventions to be able to figure out how are we best providing support, which is what we do within the community hub and spoke based system. So I think that to the spirit of this, again, knowing that there are workforce challenges and we may lose a clinician or lose a nurse here or there, the system as we develop it looks very similar in the community versus in the incarcerative facilities. I do think one of the things that looks different, and it is intentionally looks different, was I remember watching the other representative who sponsored the bill talk about what he referred to as interim dosing and made the comment that folks could only do that for 4 months. So what we actually do is that for methadone, for those individuals who are either coming in on methadone or who are determined that their response to buprenorphine just isn't as good as we'd like it, and then we look at methadone as a next option, what we do for those folks is we actually do it under what's called an SMA 168 exemption. So those individuals can receive medication ongoing into perpetuity. What we did was just debundled the counseling and said, rather than having the counseling done at the hub, these people receive medications. We give them the medications through the Department of Corrections. Department of Corrections holds on to it as kind of a reasonable accommodation for their inability to come in, because we don't want to transfer folks in and out of correctional facilities on a regular basis. And then that they too would be able to avail themselves of all the same counseling, recovery support services, and risk management and risk reduction services that are available to anyone else within that incarcerated facility. So I think we tried to do that. And again, it looks a little bit different, but not different than, say, an individual who's in a hub who ends up going into a nursing home for subacute rehabilitation for a given period of time. We provide the medications to that facility. They administer that. When the person is able to come home, they come home and they receive the services within that kind of skilled nursing facility that is provided.
So let me also let folks know what's in statute for how a person who is an inmate, this is an inmate, which is a detainee and a sentenced person, that if that person has been receiving opioid use disorder medication prior to entering a facility, they will continue to receive the medication prescribed in the course of the MOUD if for as long as is medically necessary. That's what we've put in statute. So that would be the same as what's out in the community. If at any time an inmate screens positive as having an opioid use disorder, the inmate may elect to commence buprenorphine-specific medication for the opioid use disorder if it is deemed medically necessary by a provider who's authorized to prescribe the buprenorphine, which is WellPath, I'm assuming, correct?
Mm-hmm.
The inmate shall
Yes,
be
and Madam Chair, that is,
Yep.
and at the time when we first wrote this, what was required, and it is no longer required, it was required that, federally required, that any prescriber had gone through specific training on buprenorphine. So physicians had to have gone through an 8-hour training course to receive what used to be referred to as an X license, or a buprenorphine waiver to their medical license, their DEA license. And for nurse practitioners and PAs, they had to go through a 24-hour training course in order to receive this. That has since been removed. So I think the original reference was to those individuals who had gone through the training and certification course, which was a requirement of hire for the previous contractors. That is no longer exists. So any medical provider with an active DEA license can prescribe buprenorphine.
So are you saying, Tony, that language needs to be updated that we have in statute?
We could remove the reference to any duly, however, I don't remember the exact language. It really would just be any medical provider with an active DEA license.
Because what it is, it's by a provider authorized to prescribe buprenorphine.
Yeah. And that language is fine because the person would have to have a DEA license in order to do so. It just used to be more of a reference to the fact that not only did they have to have a DEA license, they had to have a specific X waiver to their DEA license.
So one thing that you said, Tony, is that in the community, it's made available to a person who was struggling with substance use, opioid use disorder. It is made available, but it is not required. So by statute, it says if at any time an inmate screens positive as having an opioid use disorder, the inmate may elect to commence buprenorphine specific medication for opioid use disorder if it is deemed medically necessary. So is that the same as what would occur out in the community?
It is. We wanted to honor, there are a variety of ways that people, achieve recovery. Medication, we know, is the kind of considered to be the gold standard. However, the choice of medication or not medication, we always want to leave with the patient or the inmate or the offender, irrespective of their setting.
So does that help, Kevin, in answering your question about the parity?
What I'm hearing Tony say is there is parity. And in fact, my point would be that it's more than parity because we're also providing safe, affordable housing, theoretically safety, although I'm concerned about that, and the medication is accessible. Whereas if you're on the street, you don't have those advantages to become whole.
So
necessarily.
Let me just be clear. One, let's not call incarceration housing. Two, not everybody in the community is on the streets who is seeking MOUD. In fact, a large majority of them are not. Let's not perpetuate this myth that anybody who is suffering from OUD is homeless, jobless, unsheltered. That's not true. So it's not that black and white. And yes, folks who are incarcerated, I guess technically have shelter, but it's
They have food, shelter, theoretically safety. All of those things for 100% of the people incarcerated, where the people on the street is not
Again.
100%.
So I'm going to intervene here.
Yeah.
Parity is the delivery of the MOUD services. It's a delivery of the meds. It's not parity in terms of their living situation. It's not parity in terms of their economic situation. It is parity in terms of the delivery of the MOUD services, which is the medication and any therapy that may go along with it. It's a very narrow view in terms when we're looking at parity. It's about the delivery of the medication and who gets it and how they get it. Isaac?
I don't want to wade too deeply into the policy argument. I think the department's been clear, we are not a therapeutic setting. The commissioner has said that. I think that is one reason why we are pushing for the Northeast facility conversion that we talked about yesterday, to try and move us forward. I will say, I think as it regards to parity and the provision of MOD, it's sometimes difficult to achieve, kind of pure community parity, if you'd like to say it that way, in terms of some of the medications, meaning there isn't fundamental parity in the payment mechanisms, i.e. the 1115 waiver, which will allow us to gain access to some of the Medicaid coverage for folks. But for example, if you're incarcerated today and you would like to get Brixadi or Sublocade, injectable buprenorphine, you wouldn't be able to do that. The cost is prohibitive. We aren't able to take advantage of the Medicaid coverage. So I think there just needs to be also, given, as we've talked about before in testimony, some of the complexities of providing this medication within a correctional setting. I think I would encourage the committee to think about some flexibility, understanding that correctional facilities look different than hubs and spokes in the community.
James?
I don't want to get too far down this, but Isaac just mentioned this. In our hubs and spokes, can you even get injectables? I mean,
You can in some. So again, the more complicated the medication, the smaller your pool of providers. So there are some providers that do provide injectables, but it is the minority, not the majority. So it is not super inconsistent, honestly. It is a very small pool of providers comparative to the numbers who prescribe buprenorphine as an oral or even methadone that can or do provide current injectables.
So Isaac, do you see any folks coming in who are on the injectables from the community?
That's a good question. I'm sure there are some. I don't know what that number would be. We can look at that.
And we're in a rabbit hole here. What does policy dictate we do for somebody who comes in on an injectable?
So medically, that individual could honestly be given the oral medication, and depending on when they took their injection and which injection. So there are two different kinds. There is Sublocade, which is the older injectable. It is a 30-day injection. So depending on the patient's, the person's status, they may be, if they're a detainee, they are likely in and out before they're even in need of another injection. Or Brixadi, which has either a 30-day or a 7-day kind of realm. Those individuals can be given oral buprenorphine or sublingual buprenorphine, and it works the same way.
But are we required? Is that a continuity of care thing? If somebody's coming in with a preferred method of MOUD as their injectable that they've been on for, let's just theorize here, 6 months, a year, 2 years. To me, my reading, I don't have the statute in front of me. We're obligated to continue that, aren't we?
So what we say in statute, the licensed practitioner who makes the clinical judgment to discontinue a medication shall cause the reason for the discontinuance to be entered into the inmate's medical record.
So the reason could be cost. That's unfortunate. But yeah, it's a valid point that Isaac is making. It would be great if Medicaid were available to incarcerated people. I think it should be. That's not our conversation. But let's forecast a scenario where injectables become best practice. I can see that happening in very short order. And if I do think we should be using best practices for our incarcerated folks who need MOUD. That's also hand in hand a solution to the diversion problem. But I'm just down a rabbit hole here.
So we got some more questions, but I'm gonna push to move on because we're only in the first bullet with the second bullet of the first bullet.
I mean, I think it's already been useful in terms of Roman numeral 1 on Katie's sheet here. We are knocking down some of these things that we're trying to solve if we accept that there's largely parity with the community. You're not. All right, fair enough. But it seems like this is happening. We're doing this. We're considering this bill because we're unhappy with how services were provided before. We're relatively happy now with the current provider. We're almost like trying to take a snapshot. don't we have most of what we want in statute? And then the question to follow on that is, does legislative intent ever go in statute? I don't know the answer to that.
It would go, no, it would be session law.
Session law,
Yeah.
it doesn't go in the green books.
Just to say like, we want it to be equal, you know, can we put that?
So maybe one way to address this parity issue is what was mentioned. We're reliant on the contractor, the healthcare contractor. But and we're familiar with what the current contractor is doing, but once that contractor time is up and we may have a new contractor come in, there's no framework for that new contract. Maybe that's something we can look at, to look at what is that framework when the healthcare provider contract is switched to another provider. So maybe that's the focus, that we can work some language on that. That makes sense for folks?
Yeah.
Okay, let's move on. So there's improved diagnosis. Do we need anything for improved diagnosis? Again, that can maybe go into the framework of when there's a new provider. Because we are very clear.
Everyone has to be screened, right?
Yeah, they're being screened and assessed.
Within a certain time frame too, right?
Yep.
There's an infographic about it in your binders.
And then I think the bigger issue is the lack of coordinated care through reentry. And we tried to address that last year. So let me read what's in current statute for that as part of the reentry planning. This is for MOUD. Department shall commence MOUD prior to an offender's release if the offender screens positive for opioid use disorder. Medication for the disorder is medically necessary, and, not an or, and offender elects to commence medication for opioid use disorder. So all three of those have to be in place. That's why there's an and not an or. If medication for opioid use disorder is indicated and despite best efforts, induction is not possible prior to release, the department shall ensure comprehensive care coordination with a community-based provider. I want to make sure this next part's what we did. Yeah, this is what we did last year, this next part. If an offender takes a prescribed medication as part of an MOUD while incarcerated, and that prescription medication is both available at the facility and clinically appropriate for the offender at the time of discharge from the correctional facility, the department or its contractors shall provide the offender at the time of release with a legally permissible supply to ensure that the offender may continue taking the medication as prescribed prior to obtaining the prescription medication in the community. So we did this last year, where if person's on MOUD and they're being released to the community, they leave the facility in their hand with enough of that medication to carry them through so they can make an appointment with a hub and get connected and then get a prescription. So they could leave with 2 days supply, they could leave with 6 days supply, depending on how long. We also put in language that DOC would do the work that they could to hook up. As part of the reentry planning, the department shall inform and offer care coordination to an offender. Now, this is only for folks, it's talking about an offender, so it's only talking about folks who are sentenced, it's not talking about detainees in this reentry. If people want to expand that to detainees, DOC really needs to weigh in, because there's a lot of issues around a detainee being released. Okay, so last year we only stated that for sentenced folks, upon release, go in hand with some of the medication for the opioid use until they can set up an appointment with a hub. And as part of the reentry planning, the DOC shall inform and offer care coordination to an offender to expedite access to counseling and behavioral therapies within the community. As part of reentry planning, the department or its contractor shall identify any necessary licensed healthcare provider or opioid use disorder treatment program or both, and schedule an intake appointment for the offender with the providers or treatment program or both to ensure that the offender can continue treatment in the community as part of the offender's reentry plan. The department or its contractor may employ or contract with a caseworker or health navigator to assist with scheduling any healthcare appointments in the community. That's for folks who are on, I'm going to say MAT instead of MOUD. So we put that in place last year. And we had a 10-1 vote in the committee for that bill.
Trying to remember the conversation. I know we got to the 10-1. Was the one?
One was the person that felt it didn't go far enough.
Yeah, yeah. So that's.
And that's what's
something to hear. Yeah, yeah.
Let's lay the groundwork for folks to understand.
I'm getting to the current, I'm looking at H32 and how it's phrased in here.
So just from that, do we have, and you may have said that, it might have come up already, I just don't remember it. Do we have data on folks who are coming out of DOC and how they are handling their health reentry plans? And are they sticking to it? Is there data on that?
Depends what their status is. I mean,
Like, are they getting their meds and taking them for the week and then going to their doc and everything's good, or is there issues with that?
do you have your hand up?
Yeah, like it's not apples to apples, but I wonder if anything could inform the conversation. Like the state does run a psychiatric hospital where people are involuntarily held and need a transition plan. I just wonder if there's any lessons we can take from that with, it's not the same medication, but it's heavy duty psychotropic drugs in some cases. And what do those transition plans look like? How are they discharged? How do you make sure everybody gets it? I'm just thinking some lessons maybe learned in that.
And if we're not currently requiring them to report in after they leave, then that might be helpful to us understanding whether it's effective and to them because there's accountability. I don't know whether that's part of the statute is they need to report in.
Well, then you get in, if it's a furlough, it's a condition of release.
Right.
The DOC would set. If it's a parolee, it's a condition that the parole board would have to set.
Right.
So that's how it would play out.
But it's just a release. You can't.
Well, then they would max out. If you're only dealing with folks who are sentenced, then they would max out. If you're dealing with sentenced population and they're released prior to the time that they're maxed out their sentence, they will either be on furlough or parole, and there's conditions to those release. Now, could we require that a condition on that release is for them, if they're on MOUD, to check in? That's something to talk to DOC about and the parole board, because those are the folks in the driver's seat for that. So, Joe, did you have your hand up?
No, I did not.
Okay. Troy,
H32 puts it on their case manager.
it's on their case manager.
Want me to read it?
Yeah, what section is it?
I want to get to, because there's a 7-day
Right.
gap here, that's on page 10. And then when you get down into page 11, ensure that the case manager monitors the individual's adherence to a treatment for opioid use disorder and provides support for long-term.
It ensures a case manager monitors the individual's adherence to.
That's new, right?
Yep.
Yeah, I don't have.
That's no. So is the committee interested in having some check when the sentenced person meets their minimum and is eligible for release? Is the committee interested in looking into having that person check in to make sure they're abiding by their MOUD?
It's shifting it off of the case manager and onto the,
I'm not saying one way or the other. I'm just trying to get a feel for where the committee members are on that. Where are the committee members? I'm gonna hold on,
Yeah.
Roy. I want folks to start weighing in here.
I mean, I'd say yes, on some level. I don't know if it's case manager or who it is, because I don't know it well enough. It seems like that would be a positive thing for all involved. But anyway, that's my thought.
Yeah, I don't mind the idea. I like the idea, but whether somebody themselves is going to accurately report, that's one thing. But also if it's just those who have been furloughed or paroled, there's no way to make somebody who's been released and filled their whole time. So you're not getting the whole picture. So you get a partial picture, which is better than no pictures most of the time. But self-reporting is, I don't know how accurate and valid that is. But I like the idea in theory, but in practice, I'm not sure.
Other folks? Committee members? We gotta figure out, is this something we wanna do or not?
It's more practical than the case manager trying to reach out and get the information. And I also know from personal experience, not myself, but my sons, when they know that there's a possibility of having a random drug test, it keeps them on their toes more than if they don't have that.
So I'm just reminding folks, when a person is sentenced and released, because that's who we're talking about right now, those folks who are sentenced. Not detainees, but those folks who are sentenced. When they reach their min, they are eligible to be furloughed or eligible for parole. The conditions to those releases are set with DOC if they're furloughed and the parole board if they're paroled. The people who supervise them in the community are our P&P offices, our probation and parole. They look at those conditions and they make sure the person's complying with those conditions. That's how it plays out now. So if you want the coordinated care, once they're out in the community and to check in, I would assume, though I don't know, that would have to be a condition upon their release, and it would be their P&P officer that would check in with them. I would assume, but I don't know. Isaac?
Sorry, I have a few thoughts. I think I do want to echo Representative Gregoire's point. I mean, I always get a little bit nervous when we think about the carceral system following folks into the community, the ways in which we attach certain conditions to folks and how they might self-report that. And an example of this, I think, is through justice reinvestment, when the state did a concerted effort to try and reduce technical violations, particularly for furlough, they were sending folks back into the carceral. So as part of that process, we updated our policies so that if someone did have a positive UA urine analysis screen, folks wouldn't be reincarcerated for that. We've really tried, I think, as a department to shift towards, again, more rehabilitation, support, counseling, wraparound services. The turning point model, which I know Tracy's going to be talking about this afternoon. And I think that's been very effective. I think our P&P officers will tell you themselves, they prefer to act, again, kind of more on a human services model and provide that support. And so when we do have a positive UA for someone who's on community supervision, it's more of an indicator they need additional support rather than yanked back into a correction facility. I think that's the direction we want to continue to move in as a system. Could speak for the department. I think that perhaps the most impartial data is the data that we referenced earlier, which is the data analysis that we did in conjunction with DEVA, Department of Vermont Health Access, around how many folks we can identify that they were in a correctional facility. Now they're out in the community and they're on Medicaid. Can we see if there's a claim for BUP, buprenorphine or another form of medication for opioid use disorder. That to me in aggregate might be the clearest indicator that folks are out in the community filling those scripts. And that way, I think we kind of get around some of the self-reporting or issues about, oh, if I report this, will I be yanked back?
Right.
I think maybe continuing to push on that front, I would defer, of course, to my VDH, DSU counterparts as well. But that to me sounds like it might avoid some of the pitfalls that the committee members are discussing.
That a direction the folks want to go in?
Yeah.
Like that.
And it's not about names either. It's just about, it's just about percentages, you know, just be nice to know. That's all.
Working.
Does that give you enough information? to Work something up, Katie?
So it sounds like you are adding a reporting requirement and that you want DEVA to regularly report in annually on how frequently a prescription for MOUD is being filled if
By formerly incarcerated.
by individuals who are previously incarcerated.
Is that data, Tony, that can be gleaned? I mean, for folks that are treated in the hub and spoke model, do you know, people know that they were formerly incarcerated?
That is the hardest part. I know there was a 2022 report done through the Department of Corrections in conjunction with the University of Vermont. Rick Ross and Abby Crockill, who looked at doing this, and it was relatively labor intensive. The data exists, but it's hard to know. There's no systems check that says this individual had been incarcerated. Now they're receiving community-based services and Medicaid's paying for it.
But it will become easier with the 1115 waiver because that will assign.
Yes.
So I think that's where that just fits together with that.
With the 11.
Yeah, for the sentence population.
Good question.
Mhm.
But it's, so the idea of sentence versus
Detainee.
detainees, we haven't addressed that yet in this conversation. Are we going to later, whether we want to include them or have I missed the boat?
I think we should, but I want to work through what Katie has put together.
so it's
The
later.
detainee population and the struggles that DRC has
So it's
with
a later
that.
conversation.
That's a real.
Okay, gotcha.
Well, that's a good hour conversation, half hour at least. So could that coordinated care through reentry, could that language be connected a little bit when the 1115 waiver kicks in? That we could get that data?
Yeah, so you're still focusing on getting the data.
That's what I'm thinking. I don't know where else are we still focused on the committee here?
We could put the effective
Realizing
date out
it's adding
when the waiver
effort
takes
to
effect.
people who are already doubly overloaded.
It's a committee decision.
Right, I'm just pointing that out, that they're already
Other,
overloaded.
other folks, do you want to continue that or not?
The data would be incredibly informative.
Mm-hmm. Yeah. Get it.
Yeah.
And without like too heavy of a lift.
So is it a heavier, less of a heavy lift if it's connected to the 1115 waiver?
I believe, and I want to check in with our team and I think the team of folks in the Medicaid Policy and Secretary's Office that's designing the waiver, but I believe we are signing a unique identifier code in MMIS, the claims processing system, that will tag folks who are incarcerated. And then that will be the code that also helps prompt the 90-day pre-release Medicaid coverage. So that piece, I think we can work out, but I don't want to speak for Medicaid policy in case I'm getting them into something that isn't really heavy lift for them, but
Well, and
it's doable.
just personal privacy too, right?
Yeah.
If I'm formally released, formally incarcerated, and suddenly I know I'm being tracked with whether or not I'm put prescription or not, that's messy.
I see.
Would be a
Yeah, that's
it's just like
true.
public, you know,
Yeah,
a lot of public health reporting.
yeah,
Communicable.
fair.
The reporting you get will be aggregated data and it will just be that. It will just be numbers. You know, this many people were released who were
Yeah.
on
I feel better about that.
MOUD prior to release, and now this is how many. So what a report won't get you is if you're trying to find intervention points.
Right.
that won't get you that information because it's not, this is a report just to the General Assembly.
But if the case managers know from this aggregate data that we're seeing a trend by which folks are not filling their prescriptions, we know we can at least have that talking point. I don't know. The data is good. I don't like doing what if legislation, but
It's up to the committee. Do you want Katie to draft language for this or not?
I'd be interested in exploring it. It's really hard to get your head around some of this stuff without having some of these numbers. I think it's an important first step.
Other folks, Mary nodded.
Agnostic.
Without measurement, we don't know whether it's effective or not.
I guess you go ahead, Katie.
I think there's a lot to hear from Diva about.
Well, what I'm thinking is that at least we can get it back. We can focus in who to bring in. Reduce diversion. Is that a problem we're trying to solve?
yes.
Yes, sir.
And one thing that was mentioned was waking folks up at 3 o'clock in the morning, how that's taking staff time, how that's disruptive to the whole facility, just to see if they can work enough people through the med line and have enough supervision. Joe?
To the best of my knowledge, unless I missed some testimony, we've discussed diversion, but still don't know what diversion rates are.
I have some data for you.
What diversion rates are? Is that what you asked?
Yeah, you requested.
Yeah, so we're talking about something that at least hasn't been quantified, at least in this, I guess DOCS.
Yeah.
Thank you, guys.
Yeah.
So do we,
And if we can actually measure the diversion, I'd like to know what action is being taken because of the diversion. If it's coercion, there's something we should be able to do about that. For safety's sake.
But how do you legislate this? I mean, I don't, yeah.
safest way to reduce diversion is injectables, which is very, very, very expensive.
4 times as much. I just did the math. I mean, we're not coming out of patent for like 2038 and 2032.
In what?
The injectables aren't coming out. There's patents, so generics not going to be available till like 2038 or 2032.
It's not our purview, but that's another conversation.
It's got another bill.
So are we trying to solve anything with reduced diversion or not?
Yes.
Well, I mean, I need the numbers first, but I would say so.
So how do we address it? Regardless of the numbers, how do we address it legislatively?
That is tough. It's
Yeah.
that's a
Yeah.
yeah. It's
Aside from paying a lot of money for injectables. I
Which still actually-
yeah, go ahead, Tony. Yeah.
Tony?
Yeah.
I was gonna say, even the injectables, the uptake in the community is still very limited.
Yeah.
And by adding injectables, I just want to caution, and again, this is just kind of a word of, as that system, because it has such a small number, comparatively speaking, of the almost 11,000 people at any given year who are on MOUD, you start talking 100 to 150 people who might be taking injectables. The provider pool of folks who are capable and willing to be able to provide that reduces your referral options and can then unfortunately change the access equation, where we have great access to medications comparative to any other state in the country. If we get down to the point of injectables, that would we'd really want to make sure we're targeting that, because our community capacity for those is far more limited, and could have a lot of geographic limitations around access. Unfortunately, when New York State moved to injectables, they started where they just had their corrections department give everybody injectables that they wanted to give injectables to, and then sent people out, and there was no community capacity to receive them. So they gave them an injection, but no ability necessarily to sustain those. And we wouldn't want that to occur.
It's true.
So I'm picking up, we're not trying to solve the diversion issue legislatively. We'd like to, but how do you do it legislatively? Right?
I mean, it's not that I mean, Troy probably wants to, I would like to, but I don't know necessarily how to, or it's a big deal, but also I don't know if this is Brian was alluding to, but like, there's other issues about diversion, like, you know, the bully says, give me your stuff or else, can't legislate that out of people.
No.
You know, so then if they're not giving up their MOD, they're gonna give something else up, so it becomes a much bigger issue, but.
And statute currently has. Tony, what's the method when you know diversion is happening? Like, or like.
In the community, you mean?
Does that need to be, no, well, yeah, I guess maybe for DOC, when you know diversion is happening, is there a protocol in place?
There is,
Yeah, and it's guided by WellPath, I would imagine?
it's internal departmental policy
Okay,
as response to diversion.
can we see that policy?
I think it's on our website.
It should be, WellPath would determine the medical response to that as to if an individual is tapered or what happens with the medication, but DOC would determine whether there's a disciplinary report that's written up afterwards.
But DOC is.
Be a major DR? And would that go against their good time?
I think at the
Or earn
previous
time.
iteration of the policy, it was, I believe. Now it is being downgraded. I think is that policy live?
We will be making some changes, I think, within the next 24 to 48 hours. We can share what those changes are.
I would love to see that, because there might be room in statute to guide that. Like a less punitive response to diversion.
Yeah, it's directional.
I still don't know what the rates are.
Right, yeah, all of
It
that.
didn't seem like it was a big deal when the doctor was here from WellPath.
But that's different. The WellPath response to diversion is different than DOC's response to.
Oh, okay, gotcha.
All right.
So I can quote you the percent diverted in that instance by facility and year. There's a lot of data on this. I think overall, it's given the amount of MOUD that's dispensed in facilities statewide, it's relatively small amount of diversion.
Is there one or two facilities that come to the top? Or is it comparable across?
Again, I think that also depends a little bit on the culture of the facility and how that, Northern and Newport has the highest rate of responses to diversion, followed by Northeast and St. Johnsbury. So it's at 14.8% for Northern. Overall, it's 7% statewide for 2024.
Okay,
So maybe a follow-up before we do any language is when you have updated your internal policy. And we can take a look at that. And that's.
The disparity if one facility is twice the rate, that
There's something going on.
might require policy.
Isaac, does that take into account population size? Because Northern is also the largest facility.
Yeah, it's the rate. Yeah, it's
It would still be a raise.
Okay, let's keep moving. Roman numeral 2.
Okay, so we're looking at who is responsible for delivery. Could I recap where we are after one?
Yes.
So what I heard is that there is an interest in putting together a framework that sort of sets up best practices for providers of MOUD at a correctional setting, and that we're going to circle back and talk about what that framework of best practices looks like. So that's one flag. We talked a little bit about adding a report, asking DIVA in consultation with UOC to annually provide a report on those prescriptions that have been filled regularly by people who exited a correctional facility and they were receiving MOUD. And that would take effect when the 1115 waiver takes effect. There were concerns raised that I'm going to flag that I heard while you were talking. There was a concern about, do you have to give somebody the same medication that they came in on? I was looking at the language in statute and it does refer back to having them receive that medication, which is pretty specific. I could see an interpretation that medication would mean what they came in on. So I'm flagging that as something that we should at least pay attention to. And I also want to continue to flag the, when somebody is exiting the facility, we still have that conflict of how much medication they receive because both statutes apply. One that says the legally permissible amount and the other one says 28-day supply.
Well, that's for non-MOED.
That was.
Yeah.
So-
No, and in the new bill, it's,
Oh,
but in the existing language, it just says medication. It doesn't specify MOU.
But our intent, we spent a lot of time on this last year. Our intent for that 28-day supply is not the MOUD.
So I can go ahead and clean that up and you're good with the 28 days, the legally permissible amount.
It would be your heart medication, cholesterol, blood pressure, that type of thing. You go out, that's what the current WellPath contract is.
Okay.
That we were really clear, for folks who were here last year, we were really clear there was a difference between the medication that people were on for other health issues than the MOUD. It was for the MOUD, you only get enough supply before you can get into a hub.
Okay, so I'll clean that.
We were real clear, and we were real clear, it was only for offenders, not inmates.
Okay. Okay.
We were real clear on that. We spent a lot of time in this committee on that last year.
So if that recap sounds accurate, Roman numeral 2 focuses on providers. Who is responsible for delivery of MOUD at a correctional facility?
So do you do it with in-house DOC staff? So delivery of, is it med lines that we're looking at, or is it the person who decides whether or not someone's on MOUD is WellPath, it's your medical provider. It is delivered to the person in a med line that is given out by the medical provider, but there's correctional staff there to provide security. Correct?
So this question could be broader than just delivery. Who is responsible for making medical decisions about MOUD? Maybe that's a better way to phrase it.
I mean, in an ideal world, in my ideal world anyway, we would be moving away from privatized healthcare in our correctional facilities. That's not reality right now. We don't have a choice right now as WellPath, it's our providers. So I would love to mess with this. And I would love to move us towards a system where DOC become, and I've asked this question, you know, a federally certified delivery program. What's it called? OTP.
Mm-hmm.
I don't know if there's appetite in the committee to move in that direction right now.
I think the committee is trying to get their feet under them, trying to understand DOC. And all the layers.
Yeah, I agree with everything Troy said, including that it's unlikely we shift models anytime soon, but I am curious about just sort of the continuity between contracts there. And is there somebody like, you know, I'm sorry, I'm spacing on her name, but do we have a state employee with a medical background who can serve as the bridge between the contracts there? And could that person maybe have a role in developing some of this protocol and procedures here so that there is consistent care between contractors? That's what I'm worried about as far as it pertains to this.
Yeah, I'm with you.
So
apparently we do not have one right now.
what we do, what's her name? She's been here with Dr. What is it? Aviva.
She's not a clinician.
She's not a clinician.
But I know that we do, when we work on the scope of the RFP, which takes a considerable amount of time. Pretty thick, that RFP, we send it to you, it's like hundreds of pages, right? That I believe is developed in conjunction with our partners at VDH and others. It does receive that.
Tony's nodding.
We did have a medical director that recently retired maybe a year or two ago, Dr. Strenio, right? And we have had kind of different models in the past.
Yeah, we did just hire someone though, who will report directly to Aviva that has more oversight directly over the contract. So that will be a larger function of the role, and he does have some medical background.
Yeah, and we also have Brenda, so that's good. Yeah.
And what are the safeguards right now between contracts? If you know you're going out for that RFP, is there anything that requires you to maintain, in this case, a consistent and kind of clear MOUD philosophy?
I think this is gonna sound really soft, but I would say DOC's and our values would be
Right.
safeguards.
And state law. Yes.
So again, that's what I'm wondering, the state law aspects of this, because we are at the whim of, right now, I really like our commissioner. Right now, I really like our medical director for WellPath. And I have confidence that we didn't have even 2 years ago. Not necessarily, I think I had confidence in the commissioner from the start. But I'm worried that we're at the whim of how long a commissioner stays in place, right? We've talked about how long culture change takes and how difficult it is to enact long-term culture change when the direction of any given agency changes, and it has for DOC at such regular intervals. So that's what I'm worried about. And it's similar to the worries I articulated at the beginning of this conversation. How do we safeguard that when we get, again, who called it a snapshot? I think Brian did. When we see things are working, how do we get that to stick around? Even if the commissioner leaves, even if WellPath leaves, even if Dr. Uliger leaves, that's what I'm worried about. And how much of that can we do with statute?
And those changes can take place private or state run.
Yeah.
Could be the administration changes,
No disagreement.
so having those safeguards, as you say, matters for more than just private or public.
But to the degree that we're talking about MOUD and its delivery in facilities, isn't the answer automatically whoever's the medical director at that time? And so if it's WellPath on day one, and if it's Medwell on day two, it's whoever the hell it is.
That's what I'm worried about.
I know, but
Yes.
I don't know that there's another answer.
So one thing in our first Roman numeral, we did want to put in some kind of a framework for when there's a transition to another provider. So that kind of covers the second bullet. I think we're kind of clear, it's not really going to be in-house DOC staff. Picking that up. So if we work the framework, I think we understand the WellPath, and then a new contract for a new provider will happen in a couple of years. But if we have that framework around for that transition, would help address that second bullet. The third bullet, should the delivery of MOUD in our correctional facilities be done by folks on the outside? Should that be done by folks on the outside? And can that be done with an MOU or otherwise? And the question I keep coming back to, when a person becomes incarcerated, they lose their health insurance. They had it to begin with. Do they lose their primary care provider if they're incarcerated for a length of time? Does the primary care provider have any say over that person receiving health care while they're incarcerated? It's a sentenced individual is what I'm more focused in, because detainees, they could be there for 2 years, so that question would apply to a detainee. But what happens with that relationship for that person who becomes incarcerated and is sentenced with their primary care provider? What happens
Dr.
now?
Ulinger testified to that, right? That it's best practice, and he's trying to encourage it and inculcate it among his staff to check in with the primary provider, but it was not happening nearly enough.
But does the primary care provider say what type of health care the person should be receiving? They can consult with them, but who makes that final decision in terms of what medication the person's receiving for blood pressure, cholesterol, more, and MOUD? Who right now legally has that responsibility? Can a private provider on the outside prescribe medication and prescribe care to a person who's incarcerated.
Technically, the individual would be in the custody of the commissioner. I can just foresee operationally some potential pitfalls again of, it's a continue on the injectable front, of physician says, well, I would like my patient to be on sublimating. That's not in our current formulary. And if we did add it, I'm sure there'd be potentially a huge budget increase that this committee would consider as well.
Just want to put that out there, because testimony we've received in the past when we've worked on medication for prescriptions, the primary care provider has very limited say over the delivery of healthcare services to one of their patients once they're incarcerated. And they don't see them. I mean, you can't have a yearly medical exam with your primary care provider. I just want to put that out on the table, folks, to kind of understand when a person's incarcerated, it's a whole delivery system.
And that's a whole bag of worms, right? Because if the commissioner is responsible, which legally he is, or she is, I mean, this, you'd want more control over. I'm not saying it's right from a humanitarian standpoint, but legally, relinquishing control of healthcare or anything else to somebody outside of your facility would be a liability to you and to the state. Again, that's legal versus humanitarian, whatever, but.
Isn't the commissioner responsible as law is written right now?
It's under the custody,
Right.
under the custody of the state.
So the question is how does that person fulfill that obligation currently?
Well, that leads into the hub and spoke model. Do we reach out and have an MOU, does DOC have an MOU with the hub and spoke folks that would determine what type of medication or the delivery of MOUD in our facilities?
Madam
Third
Chair,
bullet. Yes.
for folks that are on methadone, the hub provider does maintain medical authority in dosing. And so there is regular coordination of care, and that happens because legally the medication has to come through an OTP or an opioid treatment program. So we have MOUs in place with WellPath. We had them in place with the previous contractor, so that basically what occurs is, irrespective of where the person is incarcerated. So thinking of women, the women's facility is all in Chittenden. We have MOUs that basically govern all of the clinics together, and then the clinics in conjunction with WellPath. So a woman is receiving care in Brattleboro, is incarcerated in Chittenden. The MOU functions to that the Brattleboro medical provider utilizes the Chittenden clinic in Burlington to provide the medication to Chittenden's correctional facility. So those MOUs for that medication continues in existence.
That's because a correctional facility cannot be a hub.
Yeah. I mean, basically to, and I know this has come up, each facility, in order to be a hub, each facility would have to be licensed as such. So it's unlike, like, I know there was previous reference to Providence and the Rhode Island folks. So Rhode Island has 6 facilities all within, a 1 block radius. It's one campus. The way that hubs get licensed is that SAMHSA licenses them, the DEA licenses them, the state certifies them. So in order to get everything, each facility has to be independently licensed, all of which would require infrastructure and bricks and mortar in some ways. We even looked at Newport, because Newport has the largest number of folks on methadone. We had actually done an exploration between the BART clinic, the the OTP, the hub in the Newport area with Northern State and came up with a number of bricks and mortar changes that would need to occur, such that even looking at what we called a medication unit, so medicine stored there, but not a full hub, both parties, Wellpath and BART, came back and said, you know what? The cost benefit analysis right now of the system functions well, and this would be a lot of work to put into it, a lot of work to put together, and a lot of costs. We're actually going to opt not to do it and continue with the existing system as we have it.
Can we require any new facility becomes an OTP?
So if you were to bring a new facility online, you could consider it. You'd want to think about what the building structures would be. I know when we first looked at this back when we were building it, I'm not even sure that a place like Chittenden that we could figure out how to do it without, substantial, and I mean substantial bricks and mortar costs. So I think we would want to be conscientious of how to do this.
Would that be considered best practices if you're looking at the design of a new facility?
Not necessarily.
Okay.
I mean, again, we only have OTPs in certain areas. The cost to be able to do an OTP, the reason we don't have them in every community, in every town, in every place is again, you're back to a cost benefit analysis. In order for them to break even financially, you're normally talking 150 patients, 200 patients at any given time just to break even. And we are still in a state where we are predominantly buprenorphine facing by intent.
Yeah. Okay.
Good. So we're going to have to continue this conversation because it is long. But what the bill proposes is that the department would execute an MOU with the closest opioid treatment program, the one that's closest to each correctional facility. And that MOU would ensure the continuity of care for inmates who are under MOUD, and that it would expand access to a full range of medication for opioid use disorder at each facility. So it would be the hub and that MOU that would determine what is provided.
It also requires the OTP by a study, right?
Study to look at OTP, right?
Or is there a certification requirement?
I thought it was a report.
It's
a certificate.
What would it take?
What would it take to obtain federal certification for an OTP program at all the correctional facilities? So where are we with the hub and spoke by MOU? Do we want to pursue that in language?
Well, Tony, you're saying there's kind of already an MOU, but it's more of a collective MOU?
For morphine, or whatever it is.
For
meth. Yes, for methadone, that is
Morphine,
correct,
meth.
sir.
For meth. Because, and we entered into that because what did have to happen, correctional officers would have to go to a hub, pick it up and bring it back to a facility. So we're trying to cut down on that.
Yeah.
But it's not the hub that directs what kind of care the person receives in the facility. So do we want to expand that a hub and a spoke would have a say over the delivery of MOUD in a facility? Silence.
Perhaps after eating.
Is lunch in the way?
I mean, I know my answer, but yeah.
Isn't the current situation, Wellpath's director is in relationship with the hub and spoke through MOUs already, is he not?
No,
Methadone.
no, just for methadone.
Okay.
Just so that the
Just for methadone, right.
just so that the methadone can be delivered to the facility and stored securely.
Right.
That's, it's not talking about providing a care within the facility. Having an MOU with a hub and a spoke The hub and the spoke would determine the care of the person while they're incarcerated.
Instead of WellPath currently.
Right. It depends what that MOU would say.
And that was not something that, he wanted to do.
Who's he?
The Dr. Uliger. He did not like the idea of that at all.
And again, I have a lot of faith. It's largely intuitive right now, but I have a lot of faith in Dr. Uliger and his commitment and his practice. I'm worried about what happens after, right? And what are the belts and suspenders that we can put in place through policy that guarantees the level of service that we're getting right now, the snapshot, persists.
So is that belt and suspenders? Is that an MOU?
That's what I don't know. I don't have an answer for that.
So much earlier in this discussion, did you not say, Isaac, something about the desire or ability of DOC to enter?
That's what general counsel said. I think the departments all have to be a different entity.
I see.
Yeah.
Thanks.
Where's lunch?
Good idea.
We haven't made much decision, but we're gonna continue this. We're gonna work with Katie and work with Tony to see when you can come back in and finish this, because Katie needs more information in the policy direction that we as a committee want to go, so she can put the words down on paper for that. So we will pick this up at some point in the near future to continue our conversation. So Katie, if you could work with Phil and Tony too, while you're on, kind of figure out where we can continue this conversation for that. So we're gonna break until